Recording in progress.
Good morning, honorable members. Hope I'm audible, just to test that. Honorable Minister, we can see you and we hope we can hear you. So it would appear that
Can you hear me?
Yeah, no, can hear you now.
Thank you.
I wanted to confirm I see you. You're on the platform. You're on. I take it committee support, that checking on my side, we do have the numbers to proceed.
Morning, Chairperson, that's correct, Chair.
All right, thank you. Honorable members, the Minister, Deputy Minister, the departmental people, as well as the entities that are on the platform, in particular ICASA, that will be presenting an item before this committee. Civil society structures that always follow our deliberations. Fellow South Africans who are following deliberations of the committee through platforms made possible by Parliament as a way of ensuring public participation in the work of Parliament. I will, without waste of time, just deal with the formalities of the meeting, starting with a reminder on the rules that we utilize to conduct meetings on the virtual platforms. First is to remind members and all participants that are on the platform that at all times you have to ensure that your mic is muted and your video camera is off until you are recognized by the chairperson at the time that you need to speak. They will then proceed to unmute your mic and switch on your video camera. In a situation where you experience connectivity challenges, will indicate for the permission of the chairperson that you would want your video to be switched off so as to maximize your bandwidth, and then the chairperson will then give permission in that regard. Recognize that from time to time, there may be those who lose connectivity and have to reconnect on the platform. Please ensure at all times as you do that, that your video camera is off and your mic is muted, as mics are sensitive and could therefore pick up background sounds that can interfere with the meeting. Wise point of orders allowed. Members advise that you raise your hand through your gadget, and the chair will recognize your hand, or the committee support, in the case the chair does not see your hand, will assist the chairperson. You will keep your mic muted and your video camera off until you are recognized by the chairperson. Then you'll proceed to unmute your mic and switch on your video camera. Proceed to raise the point of order on which the chairperson will rule upon in terms of the rules. I further advise not to raise unnecessary point of orders to a point where the meeting collapses on this platform. So these are just reminders, honorable members and participants, so as to ensure that our meetings proceed and that we are able to use the time allocated to us qualitatively. So that being said, it's been confirmed that we have got the number of people we need on the platform to proceed as a meeting. I just want to check first if there are apologies that have been received.
Morning, Chairperson. No apologies, just that the DG is overseas and will be replaced by Mr. Shalembi. Thank you, Chair.
Thank you. Any apology that, okay, I see, Honorable Minister, but let me just check first with the members. I'll come to you, Mr. You're noted. I just want to check the members if there's any apology that would have not reached the office that members would want to raise. It seems not. I see your hand, Honorable Minister. You're now recognized.
Thank you, Honorable Chair. Good morning, Honorable members, DM, and the entire team of DCDT, including ICASA. I just wanted to draw your attention, Chair, that to the fact that the acting chair of ICASA is also in the same trip with the DG out of the country, but the ICASA is represented. Thanks.
Okay, thank you, Honorable Minister. So those would be apologies, and I take it that the meeting approves of those apologies. I would now, as I move to the items on the agenda, as the committee support would flag, I'll request the minister to lower the hand for now, so that I know it's just the legacy hand, and recognize him for the future. Honorable members, just to place other matters on record. Honorable Mazoni, you want to tender the apology?
No, Chairperson, I don't want to tender an apology. I'd like to ask for an addition to the to the agenda of the meeting, please?
I do not understand, Honorable Mazone. What are you saying exactly?
Well, Chairperson, we received the amended program yesterday, and there is an issue that I think the committee needs to discuss. I don't know if the minister needs to be around for us to discuss it, but it deals with the removal of all public hearings regarding the SABC bill, and I would like the committee to please discuss that.
Okay, now we can take that when we deal with minutes. I take it that you left before we concluded, because that emanates from there. But it would be when we deal with minutes like we did previously. But I want to be sure that you got the program that we have, which is on the Tuesdays. We kept the dates that are outside of the slots for Tuesdays based on a discussion in the committee. But we'll deal with that when we get to minutes. So I thought you are still on apologies. So
no, great. Thank you very much, Chair.
If you are not apologizing, let me then get back to the matters I thought you should place on record. As honorable members will be aware, we had one committee member that we lost, the late Honorable Alice Mthembu. I've been made aware that there will be a new member, Honorable Hadebe, who I'm not sure if he has already been clarified and be on the platform. But if he's not on the platform yet, we'll still do that intro even in the next meeting. So which therefore takes the committee to its full complement, as we're one member short. So I thought I should make members aware. He was sworn in as a member of parliament on the 21st, which is those that were announced by this, is amongst those that were announced by the speaker officially in parliament. So that will be one issue that would place on record. The other matter would be that to allow the flow of the meeting, we'll just do a quick tribute after the minutes. I won't say to congratulate or anything, but indeed we have one employee that has been supporting the committee, who is attending the committee for the last time as an employee supporting this committee. So we'll deal with that I think towards the end, because the agenda is not long. So in that way, we will then proceed to the agenda, because Honorable Mazone spoke about the amended program. That's why I'm saying I just want to be sure that we refer to the same. We'll flight it at that time. The point would really be that there was to be a presentation on the BRP oversight today. But we're advised that the report was still to go to other cabinet processes, and therefore could not proceed with that report. We appreciate that there's been agreement, and at least that ICASA is able to brief the committee on the state of readiness, given that the election date has been announced. So we really appreciate that from the department and ICASA, as led by the ministry, that the day does not go unattended when there are important matters to deal with. And that readiness is also important for us to at least get a sense, given that the election date is out. But more importantly, because ICASA has briefed us before and tabled a plan of action that they were to follow. We are now here, and we needed to know that state of readiness. But it doesn't mean that that item will not come back to the committee. So we'll be juggling with the program on those bases and attend to it. Of course, that then takes us to the actual agenda item. And as we usually do, we'll give to the ministry the opportunity to do an overview. And that overview also helps to present an opportunity for the minister and his team to take us into confidence on any matters of public interest that we as the committee need to be aware of, as well as South Africans out there. Thereafter, Honorable Minister will then get to the presentation. Of course, I did get a sense from those members who spoke to me directly that not all of us got the presentation at the same time. And to augment that would then allow ICASA to do the presentation as a whole, just to make sure that everybody is taken on board and therefore take discussion after that. And thereafter we'll deal with the minutes in the way we dealt with them previously. The Honorable Minister.
Thank you, Honorable Chair. Good morning, Honorable members and the entire team of Parliament, DM and the DCDT team, ICASA being led by Nompuchoko Nontombane, and who will actually lead the team and even introduce when that time comes. Honorable Chair, I'll be very, very short. We are here with ICASA to present to the country the state of readiness with regard to the functions of ICASA, which are based on its founding purpose, on the Founding Act, and provided for in the Electronic Communications Act, Electoral Act of 1998, Broadcasting Act of 1999, and all those relevant acts. And then this role being aimed at regulating the broadcasting of party election broadcast on broadcasting services, regulating how to determine and prescribe the framework and guidelines for party political broadcasting and political advertisements, ensuring equitable coverage in that regard. That both includes the public sector broadcasting and the private sector broadcasting. At a risk of misrepresenting them in a job which they are meant to specialize in, if the chair so allow, I will ask Councillor Nontombane to introduce the topic and the team that is accompanying it. Thank you, Ms. Nontombane.
Thank you, Minister, and good morning again to the Honorable Chairperson as well as the members. I'm going to switch off the video shortly. So good morning again to the Honorable Chairperson as well as the Honorable members, the Minister, as well as the Deputy Minister, as well as the officials of the department who are present in this meeting, as well as any other members of the public who are with us in the meeting. As indicated earlier, we have an apology from the acting chairperson as she is away on work commitments as indicated by the minister earlier. However, I'm in this meeting accompanied by Councillor Faye, a councillor who's the deputy chairperson of the committee that is responsible for the review of the national and provincial election broadcasts and political advertisements. I'm also accompanied by the acting CEO, Ms. Fikile Khongwane, who is going to be doing the presentation on behalf of ICASA. I'm also accompanied by Advocate Giti, who's the executive for PRA, our Policy and Research and Analysis Division. I'm also accompanied by Mame Dupe Khatse, who is the project leader for this committee, as well as Mr. Nicholas Mabilane, who's the company secretary. I'm here as the chairperson of the relevant committee. And we are here, as indicated earlier, to present to the committee our state of readiness towards the national elections. And before we start with the presentation by the acting CEO, I want to again thank the committee for giving us this opportunity to come and present to you this morning in preparation for the upcoming elections. And the presentation that we have is going to take the honorable members through the detail of what we have done, particularly in terms of the proposed changes in the regulations that have since been gazetted. And it's also going to give a little bit of an update in terms of where we are since the last time we had made this presentation to the committee in June 2023. And also the detail that is going to be provided in the presentation is significant in terms of the current elections, given the likely complexities that we are likely to be dealing with, some for the very first time. And also, we have taken into account some of the submissions that we received, as well as the consultations that were undertaken by ICASA in terms of coming up with the proposal to the regulations. I'm going to therefore hand over to Fikile Khongwane to do the presentation with all of the detail, and then we will deal with the questions after the presentation. Thank you, Honorable Chair. Over to you, Sis Fikile.
Thank you, Councillor Nontombana. Honorable Chairperson, Honorable Minister, and honorable members, as well as members of the public who are here with us. Good morning. And indeed, we are honored to be here to provide an update on the status of readiness for ICASA to carry out its mandate in terms of the 2024 national and provincial elections. May I please switch off the camera to save bandwidth. Thank you.
Please proceed. Thank you.
Thank you. This is a presentation outline which I believe members are familiar with since the last time we appeared before the committee on the same issue in June, as Councillor Nontombana has indicated. Nicholas, if you could please move to the next slide. This slide just indicates the ICASA mandate that we are established in terms of Section 192 of the Constitution, which I'll talk to briefly in the next slide, and in terms of the ICASA Act of 2000. And our mandate, as members might be aware, is to regulate the electronic communications, broadcasting, and postal services in the public interest, and to ensure universal availability of high-quality services, including broadband services for all South Africans at affordable prices. Kindly move to the next slide. I would request that we move to the next slide, Nicholas, because the mission and vision of ICASA, I believe, is well known. So I will focus on this slide. This slide talks to the mandate of ICASA, as I have briefly indicated, and we are established, as I have mentioned, in terms of Section 92 of the Constitution. That section basically empowers the authority to regulate broadcasting in the public interest, and for that reason to ensure fairness and a diversity of views broadly representing South African society. Now, what empowers us exactly to deal with the elections for each election a year? We are empowered by sections 56 to 59 of the Electronic Communications Act. These sections outline how election broadcasts should be handled by broadcasters, political parties, and ICASA. We are also enjoined by the Electoral Act of 1998, which talks to elections, as it were, as well as ICASA Act 13 of 2000. And lastly, we are also enjoined by the Broadcasting Act number 4 of 1999 as amended to deal with elections. If you could please move to the next slide, Nicholas. So what is the purpose of the regulations? And for us to be here today to update the committee on the status of readiness. The purpose is to regulate broadcasting of party election broadcasts on broadcasting services, as I have indicated. It's also to determine and prescribe a framework and guidelines under which the party political broadcasts, the political advertisements, the acronyms for those are PEBs and PAs, will be conducted and carried out by various broadcasting service licensees. It is also to ensure equitable treatment of political parties, which I have also alluded to. Now, we undertook a process of reviewing the 2014 regulations. And the reason for doing that, in anticipation of the 2024 national and provincial elections, was to assess their relevance, but also to determine whether there is anything that warrants a revision for purposes of inclusion in the amended regulations. Pardon me. There are 3, if not 4, critical issues that became a focal point for ICASA in terms of the amendment of the regulations. And those included, firstly, the inclusion of independent candidates in the regulations. And that was in the main pursuant to the Constitutional Court and the amendment of the Electoral Code, which then sort of paved a way for independent candidates to contest the elections. And so in that regard, the review of regulations included the inclusion of the independent candidates, as well as the definitions of the PAs and PEBs in the regulations. Lastly, it also included the authority revisiting the principles of allocation of PEBs. If you could please move to the next, as well as the technical standards that all broadcasting licensees who would be participating during this period need to comply with during the broadcast, as it were. Fundamentally, and I think what is important is to highlight the issue of Section 59 of the ECA. Now, this section principally states that broadcasting service licensees must provide reasonable opportunities for the discussion of conflicting views and must treat all political parties equitably. If during an election period, the coverage of any broadcasting services extend to the field of elections, political parties, and issues relevant thereto. So this is what the Section 59 currently states of the ECA. And so just to explain to members what we mean by political broadcast, which are PEPs, and how that differs from political adverts, commonly known as PAs. Now, a PEP is a direct address or message broadcast free of charge. And I think we need to note that free of charge on a broadcasting service, which is intended to advance the interest of any political party. That is in terms of the Act as it is currently. Now, the definition of a PA as currently provided for in the ECA states that a PA means an advertisement broadcast on a broadcasting service and intended to advance the interest of any particular political party in exchange for money. And I think, again, that needs to be taken note of, in exchange for money. So that's the distinction in terms of the PAs and PEPs as currently enunciated in the ECA. And so with these provisions in terms of the PAs and PEPs as provided for in the Act, and taking into consideration that the Act currently does not provide for, inclusion of the independent candidates and the definition, as it were, ICASA, in its endeavor to comply with the Constitutional Court, as well as now the Amendment Electoral Act, took it upon itself to ensure that the regulations now include the independent candidates. And so the regulations in terms of PEPs and PAs does not only talk to now political parties, but it includes independent candidates, so that during the election period, then we ourselves as the authority adhere to that Constitutional Court, but also to ensure that independent candidates are also taken care of. We are aware that the Act does not currently define independent candidates. We are of the view that this will follow the amendments in due course, so that such issues are also included in the ECA going forward. If you could please move to the next slide. Thank you. So when we were here previously, advising the committee of where we were, we indicated that we had established a council committee, and we intended to review the regulations by September 2023. We also indicated that from October to December 2023, we were going to publish our draft regulations for comment, provide provincial consultations and public hearings, and analyze the submissions. We also indicated that from January to March 2024, we would be finalizing the regulations and get approval and publication of the final regulations. So where are we currently? Please move to the next slide, Nicholas. So the committee was established We consulted the SABC and the IEC. We published the draft regulations on 4 October for public comment. We held provincial workshops, which included political parties from 24 September to 9 November. We received 9 written representations from interested parties, and we held a public hearing on the 8th of December 2023. We subsequently analyzed the written and oral submissions, and the regulations were vetted, and the project was in track, and it still is. If you could please move to the next slide, Nicholas. So then, before we move to the next slide, I just want to explain something here. So we had indicated these steps as the next steps to be undertaken by the authority post-publication of the final regulations. And we had indicated then that we will commence with workshops with licensees on the published regulations in March. And I'm going to go through that momentarily, just to then explain what we have done, where are we in terms of this. Now, we indicated that upon proclamation of the election date by the state president, that would be the beginning of an election period, and then the monitoring of coverage will commence. Let me just stop here and state that as we are all aware, the proclamation was done last week, Friday. And that then, in terms of our statute, means that it is the beginning of an election period. What is an election period? And for purposes of this meeting, an election period is a period commencing with the date on which the election day is proclaimed and ending on the day immediately following upon the day on which candidates of any of the political parties are declared elected. So as it were, we are on an election period. Now, just the narration that is below these 2 blocks states that we also deal with election broadcast complaints and disputes. And these are dealt with by the Complaints and Compliance Committee of ICASA on an urgent basis in terms of the regulations governing the aspects of procedures of the CCC of ICASA 2010 as amended. This effectively means that during the election period and during our monitoring, in the event of us identifying, or any member of the public, as it were, identifying an alleged contravention by a broadcasting service, then the CCC would have to deal with those allegations on an expedited basis in terms of the regulations. Please move to the next slide. All right, I would like Nicholas to just beam a slide that talks to how we are going to implement, from an implementation process, what's going to happen next. But I think it is fundamental, a point that I almost omitted. It is fundamental to highlight that ICASA has published the regulations, the final regulations yesterday on the 26th of February 2024. Please move to the next slide. So here we wanted to share with members the graphical or the schematic representation of the implementation process or plan for the 2024 national and provincial elections. So I have just indicated that the proclamation date was done last week, 23 February, and this marked the beginning of an election period. And yesterday, ICASA published its final regulations. And from that point, since a publication of those regulations, what is going to happen is from yesterday already, we have sent out invitation letters to broadcasters for them to indicate whether they are going to carry or to participate in the elections, and for those for others to also indicate whether they are going to carry PEPs. We have planned the workshops to our broadcasting licenses to commence next week on the 5th of March. And we will commence on the 5th with the Gauteng province, and we will then move on to the other broadcasters in all the 9 provinces. These workshops are aimed at making or taking broadcasters through the regulations that we published yesterday for them to understand their rights and obligations during an election period. We are then going to compile a list of all the broadcasters who are going to respond to ICASA, indicating that they will participate in the elections. And this is over and above, you know, the SAPC that is enjoined by the Act to carry elections. Now, what we will do subsequently is to consult with the SAPC, and the data yet to be confirmed internally. And perhaps some of the members might ask a question as to why are we consulting with the SAPC on the suitable slots? And by slots, we mean the PEP slots, which are, as I indicated earlier, are the free slots provided by ICASA upon receipt of the list from the IEC. The reason why we will be consulting in the main with the SAPC is because Section 57 of the ECA enjoins the SAPC to permit a party election broadcast only during an election period, and then only if such a broadcast is produced on behalf of a political party in question or at the instance of its duty authorized representative. Now, the rationale for us to then meet with the SAPC, which is also captured in terms of the ECA, is for us to discuss the suitable slots and the schedule for the SAPC to carry out those party election broadcasts, taking into consideration, as we are enjoined by the Act, the financial and programming implications of the broadcasting services in question. Now, the next thing, once we have done that consultation with the SAPC, would be then for ICASA to wait for the final list of registered contesting political parties. And apologies, we omitted independent candidates and independent candidates from the IEC. That list will then be utilized by ICASA to allocate the PEP slots and for ICASA to proclaim an election broadcast period. And then we will commence fully fledged with the overall monitoring of elections and eventually produce the elections coverage report. So this schematic representation was just a high level just to show the members of what will happen next in terms of this process and in terms of ICASA being enjoined to deal with elections. Thank you, Honorable Chairperson. I will stop there. Thank you.
Thank you, Ms. Mumsongwan and Ma Ndombana and the team. That is it, Chairperson. Maybe the interesting part would be the independent candidates who are also going to be objects and subjects of the equitable treatment in as far as all the affected acts are concerned with regard to fairness on coverage as the election period goes from the proclamation until the date articulated by Ms. Songwan. Over to you, Chairperson.
Thank you, Honorable Minister and the ICASA team. As you unshare the presentation, I will now be looking at members who would want to interact with the presentation to raise their hand for recognition by the chairperson. You will then assist me committee support. In the case there will be those I leave. I do see that Honorable Machozi hand is up. I will then proceed and look at the others as they raise their hands. Honorable Machozi, you can proceed in the meantime. Honorable Mazzoni.
No, thank you, Chairperson. Good morning to all honorable members, ICASA, the Minister, and all other officials that are present today. No, mine would be on the slide, Chair, where they were talking about PEBs and PAs. I think political advertisement and political elections, So I wanted to check. It's just that slide is not here now. I wanted to speak to it when means a direct address or message broadcast free of charge. I can see that it says the interest of any particular political party. So I'm not sure whether maybe is it because of the independent candidates are not included here because maybe it's something that was agreed to now and it was not maybe provided for. So in terms of that, how are they going to treat the independent candidates? I can see that address of messages maybe of a launch or a rally will be free of charge, and for a political party. What happens in the case of an independent candidate? Is there anything that will be provided for them, or will they be taken as an advertisement and they will have to pay for their own maybe advertisement if there's any, or maybe there are messages that they would want to podcast? I'm not sure in terms of that. How then do we move forward? Thanks, Chair.
Honorable Machozi, Honorable Mazzoni, you are recognized. Can proceed. The Honorable Mazzoni, you are recognized. Can proceed to unmute your mic and speak.
Thank you very much, Chair. Chair, please allow me to keep my camera off so that bandwidth is saved. Chair, good morning to you once again. Good morning to all our colleagues. Morning, Minister. Chair, just on this issue of PEBs in comparison with PAs. Now, PEBs, as we know, everyone deserves a fair and equitable share of the PEBs, and that's because we enjoy a state broadcaster, a public broadcaster rather, and everyone has the right to have their message heard. So one understands fully the full involvement of all political parties, as well as now the introduction of independence in terms of the PEBs and how that is structured. But Chairperson, I am slightly concerned, and maybe it's just confusion that seeks clarity. But PAs, the paid advertising, that is a completely commercial contract that a political party will enter into with a private broadcaster. So they always have been commercial contracts that are entered into. No private broadcaster has ever been forced or has ever even aimed to have a PEB or to they don't need to seek equitable share of broadcasting rights of any political party, because it is a commercial transaction that takes place. Now, in the past, as soon as the election is promulgated, which our election has now been promulgated, you can start entering into those commercial contracts. So am I right in my assumption now that we are taking a definite difference between the stance on PEBs and the stance of PAs, and that PAs will be allowed to commence whenever political parties or independents are ready to enter into commercial agreements with private broadcasters, and there should be no problem with that. And then, as always, we wait for the regulations when it comes to PEBs. Thanks, Chairperson.
Thank you, Honorable Mazone. Honorable Bolani, you are recognized.
Thank you so much, Chairperson. And excuse me, Chair, I've got a bit of a flu, so I hope I'm audible. Chair, I think as a country, we really are entering a virgin terrain with the entrance of independence in the national and provincial elections. And I, like the two colleagues that have spoken, Honorable Mazone and Majosi, I'm also very worried about how we are going to handle independence on the PEBs. Perhaps, as the honorable members have already requested, clarity would be appreciated. This especially because the independents are not a homogeneous group, and I don't think they are really an organized group as it were. So how does ICASA coordinate to make sure that there is no issues of being in contempt of court? So what is the coordination that ICASA does with the independents? ICASA spoke about having held workshops. I'm not sure whether it was workshops with media, the respective media houses, or with candidates. If I could just be clarified on that. And also, what was the uptake on that? Are they happy with the uptake of the said workshops? And while I appreciate the issue of equitability, and again, the issue of independence, on how does ICASA plan on monitoring and ensuring that there is equitable share of that space? As I do appreciate also that there's going to be a CCC, the Compliance Committee. But a further question is, what is the capacity of the CCC? And based on previous elections, how well did they do in handling any complaints? And my question is specifically to community radio stations, which might not necessarily be equipped to provide equitable media space in their locality. So how do we make sure that, how do we balance that out? Thank you so much, Chair.
Thank you, Honorable Bolani. Is there any hand that I'm leaving behind as I give to the Ministry and the ICASA to respond?
Chair, Sorry, Chair?
Honorable Kumbo.
Yeah, Chair, it's just that I cannot raise up my hand. I don't know what's wrong with my gadget, Chair. But thank you, Chairperson, and greetings to the Minister and the honorable members and everyone in the meeting. I just want to check the status of the community broadcasters, whether they are being invited for these workshops that are going to be held or not, because I was trying to check as to whether there's an inclusion of the community broadcasters. I can see that. If I can just be clarified on that one, Chair.
Thank you, Honorable Kombo. As I said, I'll be giving to you the ministry and ICASA to respond. So, Minister, as you respond, just to concretize a point there, because I may not be able to come back on it, which has been raised by two members. You mute for now, Minister. Mute for now. Mute for now. Thank you. I'm just saying that as you respond, just to concretize the point raised by two members on community broadcasting side, that as you respond, take us through also from the understanding that a number of them have been closed, probably to license requirements or problems of signal distribution, not paid, which is an important platform as far as these elections are concerned. So what's being done in that regard as you engage with them? So that's one part. But the second part would be just generally, whether it is the SAPC or ICASA, with these independents coming in the space we need to create, I'm talking both access as well as the monitoring, which is then done by ICASA in that score, whether financially we are able to carry out the task. I think that also needs a bit of confirmation to assure South Africans that we will be able to deliver on the project. So as you respond, if you can just talk to also those matters. Thank you. You can now get in, Minister, and unmute.
Thank you very much, Chair. Thank you, honorable members. I think ICASA must have heard the questions, especially on the PEPs, to the extent that they affect independence. And Honorable Member Mazwani wants to check the extent to which that regulation affect the private contract between political parties and the slot they pay for. Honorable Member Belani wanted to hear about workshops and the capacity of the CCC to carry its work. Honorable Gumbu, Mr. Mana, is about the community broadcasters. How do they come to the space? Of course, Chair takes it further to say, how will it affect access to information? I'm using my own words, if I understand the Chair. If a number of community broadcasters are closed due to a number of reasons, of course, the issue of budget for the work. Mr. Mbana, your team.
Thank you, Minister. So if I may just start with question from Honorable Majosi. So the way that the slide is drafted is specifically from the ECA. So it's not taking into account what is in the regulations now. It's just taken as it appears in the ECA currently. So that is why it is reading the way that it is reading. If you notice, we've specifically referred to the definition as it appears in the ECA. And then to Honorable Ms. Mazzoni, I think in terms of the PEPs and the PAs, so maybe if I start with the PAs, it is correct that it is a commercial contract between the relevant broadcasters as well as the political parties and independent candidates that may want to run the PAs through the broadcasters. However, it is a requirement that those PAs that will then be run by the broadcasters, the authority is also informed of those PAs for purposes of monitoring. However, the negotiations that would then take place on a normal contractual basis, that is something that will still occur as it has been happening. But the requirement is that the authority is informed that those political parties and independent candidates will be running the PAs through the broadcasters. And then in terms of coordinating the independent candidates, I don't necessarily think that we are coordinating independent candidates, but what we have done is to reach out to everybody during the consultation process, as well as during the workshops that we have done in all of the 9 provinces, to make sure that if there are issues that we need to explain to independent candidates as well as political parties, the platforms are available for us to do so. And this is going to continue as indicated, even post the publication of the regulations. I'm going to allow Sysfix also to indicate a little bit more on how ICASA is going to be doing the monitoring. And then in terms of the community broadcasters, similarly to independent candidates, what we have done is to create platforms where community broadcasters can reach the authority either through the draft regulations when they were published, in terms of giving them an opportunity to make submissions, as well as through the workshops and the public hearing that we held, so that we can then explain to the community broadcasters that may want to run political advertisements or even the PEPs, what it is that is expected of them. So what are the obligations, what it is that they would have to do if they were to choose to run the political advertisements as well as the PEPs. And then I think the other question regarding the CCC as well as the previous experience, Sysfix is also going to touch on that. Thank you, Honorable Chair.
Sysfix.
Thank you, Honorable Minister. If I may just add on to what Councillor Ntombana has indicated to Councillor, or rather to Honorable Member Mazzoni's question. Indeed, the PAs are a commercial agreement between the political party stroke independent candidate and the broadcaster consent. However, it is critical to note that despite that being a commercial engagement between the party and or the independent candidates, in terms of the regulations and some aspects of the Act, ICASA is still enjoined to monitor those PAs. I'll just highlight one or two things, that indicate why we get involved in terms of the PAs. First and foremost, those PAs that are submitted to broadcasting service licensees during an election period, as you have correctly stated, Member Mazon, they must ensure that the political parties or an independent candidate must ensure that those PAs do not contain any material that is calculated or deemed to contain or rather provoke or incite unlawful, illegal, or any criminal act or condone criminal acts. That's the first thing that we look at as ICASA in terms of the applicable legislative framework. Secondly, we ensure that those PAs are not broadcast immediately before or after another PA or a PEP. And lastly, there are various things that we look at. And lastly, that PA is not broadcast, beyond the stipulated period before the actual polling. And lastly, which is very fundamental also for broadcasters, which is what we are going to take them through during these workshops we are starting next week. It is to ensure that a PA is clearly identified as such, and through a standard pre-recorded concluding bottom and tail disclaimer, which means as the PA commences, a licensee is supposed to indicate which this PA is by the party consent, and the broadcaster doesn't have anything to do like that with its content. And also at the end, at the tail of that PA, the broadcaster needs to have that tail disclaimer to say this was a PA by X political party or independent candidate X. So those are the things that at ICASA level are enjoined to monitor, irrespective of the fact that it's a commercial engagement between the parties and independent candidates. And I think the next question was in terms of how are we going to, I think it came from Honorable, let me check, just a second. I think it came from Honorable Tsulu to say how are we going to handle independence and to monitor equitability in terms of the PEPs. So as indicated during that schematic representation, we are going to ensure equitability in terms of the principles which are contained in the regulations that we have published yesterday. We have a table that outlines the principles of how that equitability is going to be achieved. But right now, we are not in a position to outline in detail. And the reason why that is because for ICASA to ensure that everyone gets, this and that in terms of the PEPs, we need to have that final list from the IEC, which will outline or rather indicate the number of candidates fielded, the seats currently held, and all of those things. But I think it is also important to highlight the fact that we also have in that principle contained in the regulation, we have basic allocation, where everyone who is contesting the elections, even before you look at the issues of candidates fielded and all of that, you get a slot in terms of that. And how we monitor that post the allocation is we immediately, as ICASA, after we have done the allocation of those PEBs, we publish what we call a PEB schedule. That PEB schedule indicates the times and the first of all, the names of the political parties and independent candidates and the slots and dates allocated to each one of them. And also the media platform, whether SABC or the community radio stations, who will be carrying those at a particular time. So in us monitoring that those are broadcast, we look at the schedule and listen physically to what is being broadcast by the broadcasting service licensees to ensure that broadcasting service licensees are actually airing those slots that have been allocated to political parties and independent candidates as per what ICASA has provided to those respective parties and independent candidates during the allocation of slots. I think lastly, again, the question from Honorable Tsulu was, did it was in respect of the Triple C handling those cases. So we can confidently state that the Triple C is equipped to hear those matters that are brought in respect of allegations of contraventions that are brought before it. In 2021, or rather during the municipal elections, we forwarded above 18 cases, if not 17, to the Triple C, and those were heard by the Triple C, and judgments or rather recommendations were made, and they included both commercial licensees as well as community radio stations who contravened respective regulations in terms of coverage of elections. So we can safely state here that the Triple C is well equipped to deal with those contraventions, and we are confident that should there be any contraventions in the impending elections that are identified by ICASA and or brought to the Triple C by other members of the public, including other licensees, the Triple C will be able to handle those. I think the other question was from Honorable Gumbo.
Hold a bit. I see your hand, Honorable Mazon. On what point are you raising? On what point are you raising?
Chair, I'm not raising on a point of order. I think the member should finish what she's saying, but I would like to question what she has raised afterwards, if possible. Thank you, Chair.
Okay, we'll deal with that when we check if there are follow-ups. Then proceed. Come on.
Thank you, Honorable Maneli. So I think the other question was from Honorable Gumbu about the status of community broadcasters and whether they are going to be invited and workshopped regarding the regulations and elections. Yes, they are going to be invited, because they form part of the entities that need to be, educated on their rights and obligations during the election period. And a question has been raised regarding the fact that a number of them have been closed it is true, a number of them have been closed, and their closure from ICASA perspective really is in terms of them not lodging their applications, renewal applications timeously. And in terms of the Act, we have no legislative or even regulatory power to condone late filing. But what has happened yesterday is that we have received some correspondence from, you know, an NGO that is representing, I would say, the community broadcasters, and they listed a number of community radio stations and requested that for the period leading up to the elections, may we please grant them special events licenses in order for them to, you know, to make sure that they broadcast election related matters. So those are done in terms of what we call the special events licenses, and we regulate them in terms of the processes and procedures regulations. We are yet to respond to that NGO, advising them that any licensee that is listed in that correspondence may apply to the authority, and in terms of the processes and procedures regulations, to broadcast in terms of special events provisions, and each application will be dealt with on its merit. So we have already received that request, but we are going to deal with each application upon that radio station that has been shut down, lodging an application for the authority to proceed. And if they meet the requirements, and then they will be considered accordingly. I'll stop there. I'm not sure, Councillor Ntombana, whether I have left out any question, you know, in that regard. You will advise. Thank you.
Come in, Ntombana.
Through you, Honorable Chair, we will wait for follow-up questions at this point. Thank you very much.
Thank you, Councillor. Maybe the chair will explain it further. I guess sadly expressed in his concern is maybe some of the questions might be answered by the MDDA. The extent to which everything is done within the law, that no community broadcaster is prevented from participating to enhance access to information by ordinary voters within the law. But I think the chair is better placed to express himself on that matter. But that's how far we go, Chair.
Thank you, Minister and the team. Honorable Mazzone would have raised the hand for a follow-up, but as she does that, you'd know the point about the budget has not been responded to. As I said, it speaks to
yes,
ICASA. But as well as that, you've captured the point correctly, because it's about access when we talk to those community radio stations, and nothing outside of the law. But what is it that needs to be done to ensure that that info that access is available, especially with the numbers you have, so that you do not have everything channeled to the SAPC when probably other platforms could have been used. So you captured it correctly, please. But I'm just saying the budget, probably want to come back to it as part of answering to follow-up questions. Let's deal with Honorable Mazzone. If you can ask your follow-up question that you wanted to ask, and any other member, and then we allow you then to respond as a way of concluding on that. Honorable Mazzone.
Thank you very much, Chairperson. Chairperson, just to the members of the ICASA board, thank you for your responses, but I do need some clarity on a few things. Chairperson, it has been the case in the past that political parties have never had to inform ICASA of commercial PA contracts that they enter into. Now, I fully understand that we have to adhere to certain regulations, such as making sure that adverts are not unlawful, do not incite violence, etc., etc. But that's also one of the reasons we have the Broadcasting Complaints Commission, as far as I understand, is to make sure that anything that's broadcast, be it on paid broadcast, be it on free-to-air broadcasting, will never overstep those particular boundaries. So that's my first question: is why is ICASA now requesting that we inform ICASA of private commercial partnerships that will be entered into between political parties and the private broadcasters? Chair, then is it not the BSL who are responsible for informing ICASA once they've entered into these agreements? I assume yes. So I would say that is possibly somewhere that there's been a little bit of confusion. Chairperson, the regulations spell out exactly how to treat PAs. So I don't understand why there will be further involvement by ICASA. Is it simply to make sure that everyone's on the same page? Is it to make sure that maybe newcomers to the political arena understand the way things are done? But this is certainly not the way a commercial agreement has been entered into in the past. And once again, we have to make a definitive and decisive separation between PAs and between PEBs, because we fully understand that PEBs are in a completely different category to PAs. So that's fine. Chairperson, it's my opinion that ICASA actually does not have a right to have any access to our PAs, and they don't need to know the details of when and how those PAs will be aired. That's commercially sensitive information, and that's why you enter into a commercial agreement with a private broadcaster. Now, yes, I understand that a schedule will be sent out of PEBs, and that you don't want adverts airing directly one after the other. But Chairperson, quite frankly, with the amount of political parties that could possibly be entering into this political arena, and in the lead up to this political election on May the 29th, you may have a situation where it's almost impossible to avoid two political party adverts airing one after the other. So, I mean, how does ICASA seem to think it would be fair, or how do they see that particular scenario rolling out? And then, Chair, lastly, all PAs, and it's always been, have always ended with the line, "This ad was paid for by the political party that has just released the advert." It's the byline. It's the ending of the advert. It has always been the case. So I don't see why that should be any different. And I really can't understand why a workshop would be held to ensure that would happen. That's part of the regulations. That's part of general knowledge, common sense, and it's already in writing. So I am finding it slightly confusing as to why there is now this sudden and almost, I don't want to say oppressive, but rather intrusive ICASA involvement when it comes to political parties entering into commercial agreements with private broadcasters. Thank you, Chairperson.
Thank you, Honorable Mazon. Any other follow-up question? If not, as I give the Minister the team maybe it will also be important, because we seem to have different interpretations at times, that you are saying once these are publicized, you are now entering a space that it's now the electioneering. So you may need to clarify this point so that we do not put something on ICASA if it is not really what they need to be monitoring. That the election date declaration or publication of your regulations does not mean the end of government. Whether it's a provincial government, local government, or national government. And from time to time, those would be communicating to the people of South Africa on their service delivery programs or any plans they have. And sometimes this gets to be confused because those people come from political parties, and yet they are communicating a government program. So as you come back to respond in this last point, it may be important to locate that in your understanding of what electioneering is, which is in the purview of ICASA monitoring from a point of regulation. I hope Minister and the team, you got that, be able to clarify as you clarify the budgets too. Can I give then over to you?
Thank you. Let me start with the money, Chairperson. SIBC actually stated this, and I've also confirmed it this morning, that they have budgeted for elections. But I think because the ICASA is here, they are better placed to put their case. Secondly, I think the team will respond to Honorable Mazoni, but I think some of the answers came from your comments, Chair, that if there's one thing you never leave to common sense is the equitable coverage and the legal running of elections. Elections are sometimes almost like judiciary when we talk that independence, is that they must be seen to be so fair in all aspects. But the team will respond, because what I wanted to say, ICASA is not a competitor to any other party. It's a regulator. I am not sure, but ICASA will explain what are the commercial secrets, but I'm sure the law should be governing all those. But I just wanted to make the point that ICASA is not a competitor with anyone. It is there to regulate the environment for the fair running of elections and continuous adherence to the laws of the country. But Ntombana and your team, can you show your better understanding of issues that have been raised and assist all of us to be on the same page with yourselves?
Thank you, Minister. I'm going to start probably with the last point you made regarding the budget. So we did set aside some money, particularly to deal with the work that is required in the regulations, in the drafting of the regulations, as well as the post work during the monitoring. And I think in the last meeting, when we came before this committee, we did indicate that there are financial constraints that we are facing, and also because we will be doing we will be dealing with the elections as we've never done before. So we obviously need to have sufficient funds to deal with whatever that we need to do in terms of the work of ICASA as the regulator. We've therefore had to reprioritize and take money wherever it is available in order to make sure that we are able to have funds set aside for the work that needs to be done by the authority. And then in terms of community broadcasters, I think that question, the only way I can respond to it is that, as indicated, we did reach out to broadcasters. In fact, we sent out information to them to indicate that we are busy with the drafting of the regulations, and we will be conducting workshops, and any broadcaster that is willing to run PAs or PEBs is free to do so. The only thing that is required of them is for them to then make sure that they are doing that within what is in the law, in terms of what is in the regulations. And one would hope that as many community broadcasters as possible will participate, simply because we don't know the numbers that we'll be dealing with, given that there's the inclusion of independent candidates. And during the workshop, if it's any consolation, during the workshops that we conducted across the provinces, we did get a lot of interest from the community broadcasters that participated, with them wanting to know what are the issues that they need to be aware of if they want to run political advertisements, as well as if they want to run the PEPs. And that information was made available during those workshops. And even post the workshops, we did say that anyone who wants information, excuse me, or wants clarity in terms of what it is that is expected of them in terms of the regulations when they participate during the election period in running the PAs and the PEPs, we've made our officials available to answer those questions. So that opportunity is available to all broadcasters in terms of them participating in the elections. But we will only know when we start getting the list of broadcasters that are going to be running the PEPs and the PAs, the extent to which they will be involved during the elections. And then in terms of the second or the other question that was raised by Honorable Member Mazoni regarding the PAs and whether we are in fact intervening with the commercial negotiations that would ordinarily take place between the broadcaster and the political party or the independent candidates. I think we just need to clarify what it is that we are saying there. I'm going to allow Sysfix to perhaps give a little bit more detail. The only thing that I would add there is simply that we are saying that a broadcaster which is going to be running the PA needs to inform the authority, because we do need to monitor whether the PA is being run in terms of what is provided for in the regulations. But I'm going to hand over to Sysfix to then perhaps give a little bit more detail so that we can just clarify what it is that we are expecting when we have the PAs run by the broadcasters. Thank you, Minister. Through you, if I can hand over to Sysfix.
Thank you.
That's okay.
Thank you.
It's okay.
Oh, thank you, Honorable Maneli. Thanks, Councillor Nontomban. So I think first and foremost, it is pivotal to indicate that ICASA is not regulating political parties. Or rather what we have just said, relates to the licensees of ICASA and what they need to do during elections. But for them to do what they need to do in accordance with what the law and the regulations prescribe, political parties and independent candidates need to be aware of what they must or must not submit for transmission by those licenses. And so, Councillor Mazzoni, you are correct that there is a commercial engagement or agreement between political parties, independent candidates, and the broadcasters concerned. So what one can say in this regard is that commercial sensitive information is not what we say we want as ICASA, either from political parties, which we don't regulate, or broadcasting services, as it were. What we are talking about is the content that eventually lends itself to the public who are recipients of that content. We are a creature of statute, and Section 56 talks to what is prohibited in terms of party, in terms of PAs and all of that. The regulations are just cementing what we are empowered to do in terms of the Act. It is for this reason that we regurgitate or expand in terms of the regulations what broadcasters need not do in them broadcasting those PAs, which is a commercial engagement or agreement between themselves and parties, independent candidates, consent. We state and broadcasters are aware of that, those who have been in the field for the longest time, that even the ECA, besides the regulations, it states that they must be wary, they must be mindful of broadcasting PAs, which also tallies with PEBs, but I'll talk to the PAs, of broadcasting PAs which have a content, for example, which is likely to incite violence, amongst other things, and all of those. So we are enjoined as ICASA to make sure that those PAs are compliant with the statute, are compliant with the regulations. Detailed disclaimer to say it is not understandable why now this is a requirement. It has always been a requirement, and even in the 2021 local elections. And perhaps the reason that we need to understand why we have that tail disclaimer, it is in the main to protect broadcasters. And maybe protect is a strong word to use, but it is to primarily protect broadcasters so that as they broadcast or transmit those PAs, it is very clear that it is not the broadcaster's content, but a content that has been generated and submitted to them by the party consent or independent candidate consent. So in the main, it is basically for the broadcaster to indicate out there that this is not my content as the broadcaster, but I have received this content from the political party consent. So I thought maybe it is just important to just emphasize that we are not regulating the, that sensitive information that you submit to licensees. What we regulate is the content itself that ends up lending to the South African public. I think I'll stop there. There was a question that was asked, which I believe Mr. Nketeleni would like to respond to. Thank you.
Can he do that?
Thank you very much, Honorable Chairperson and Honorable Minister and the Deputy Minister and the members. I think Ms. Hlongwane has covered the issue in the main. The point that I wanted to raise, Chair, was that the provision governing the political advertisement has been there since the 2014 regulation. What we have done with the amended regulation was simply to add to include the independent candidates so that they are also governed by the provision that governs the broadcast of political advertisement. And as Ms. Hlongwane has indicated, whatever that we are doing, Chairperson, is governed in terms of Section 58 of the ECA, which then indicates how the political advertisement should then be handled by the broadcasting service licensees. There is nothing else that we are doing. What we are doing is aligned with the law, and what we have prescribed is then what we are empowered to prescribe in terms of the ECA. Thank you, Chair.
Thank you. There we go, Chairperson.
Minister, I thought you were responding.
In terms of?
I've asked that question and it's a deliberate question.
Which
about
question,
government that works versus the electioneering and whether that's in the purview of ICASA, so that we don't deal with such matters when it happens. But there's clarity. So if ICASA would want to respond to that.
Chair, not to be nagging. I think you're asking an important question. Can you simplify it more?
Okay, let me start, Minister. The point I was raising was that ICASA said after publicizing the regulations, then they get to a period they call electioneering, and that's when they monitor this part about parties, whether it's the PBs and so on. So the question I was asking, so that it's clarified, you can hear me.
I hope it's not myself. Your connectivity, I hope it's not. If it's much a trouble with your connectivity.
I'm just not sure now because I didn't get an indication that I'm saying on my side that the network is unstable. So,
Chair, you're very clear on our side.
Yeah, okay. I think the point I'm asking, I'm sure then ICASA wants to respond to this. I'm saying the electioneering period does not take away the fact that there is government, whether provincial governments, national government, or local governments, who have also a duty and obligation to interact with society around their service delivery and the plans to respond to some of the challenges that the country faces. And sometimes this is seen as an unfair advantage to those because they are drawn also from political parties, whether it's a minister or president. But at that time, it's the discharge of a government duty. So I was saying it's important to clarify whether that's considered to be in the purview of ICASA or they play any role in that regard, as others may throw it as electioneering whilst government is performing its work. I hope the minister did get this point, but ICASA can.
No. I think ICASA will respond as ICASA. I think the point you are making is a point that at times I've raised with SABC, that the government of the day will work every day and do the work it's supposed to do. And I deliberately, at the risk of being viewed being naughty, I said, if Alan Winde, the Premier of Western Cape, wants to communicate to the Western Cape people in his capacity as a Premier doing his work, I would not expect any other party to say, because the Premier was doing his work, then I must also do that work. But if he presents, he gets covered. I also need clarification from ICASA on this. If he gets covered in his capacity as a leader of TA, that becomes a different issue. I think you are raising an important question, but let ICASA educate us on this. Ntombana?
Thank you, Honorable Minister, for the question. I don't know if I fully understand the point that is being made, but what ICASA is doing is to set out its work during the election period as provided for in the ECA, as well as amplified in the regulations, and particularly to make sure that the public is not misinformed during the election period, but also making sure that the broadcasters are also doing or at least participating during the election period within the confines of the law. So what we do really is limited to the role of the regulator in terms of setting out the rules, if I can put it like that, during the election period, and making sure that those rules are fair and also apply across, excuse me, whether you are looking at political parties and independent candidates, but also whether you are looking at broadcasters. And what we are regulating is really limited to what is mandated for ICASA to do within the law. Anything that is beyond that is not something that ICASA would be involved in. And we also, as indicated earlier, are mindful of the nature of the elections that we have this year. And we are particularly making sure that these rules and, or at least these provisions, if I may put it like that, in the regulations as well as in the Act, are also clear, particularly to independent candidates, as well as when broadcasters are participating, they are also clear that they should be treating political parties as well as independent candidates fairly, and also to the extent possible equally, in terms of, for example, giving access as well as the communication that is made available to the general members of the public. And then I'm going to also just ask Sysfix to add or even Advocate Giti if there's anything that I might have missed in terms of the question of the Honorable Chair. Thank you, Minister.
Just as you go there, Honorable Mazone, what point are you raising? Or it's just an unfortunate hand? Can proceed, Ms.
Thank you, Honorable Maneli. I think Councillor Nontombana has covered me in terms of saying that in terms of the regulations, we are limited on what to regulate, and what the Honorable has asked is something that we don't regulate. However, in our regulations, we have a section that talks to the guidelines. It's just the guidelines for broadcasters, you know, to take certain things into consideration. And one of which is to, you know, basically caution broadcasters to distinguish between a government program or political program rather, because I think, as Honorable Minister has indicated, at the end of the day, the government needs to do what it needs to do. So under the guidelines, we have a section that talks to coverage of government. And there we guide broadcasters, or, you know, on what to look out for as a means of caution, you know, for example, to say they must recognize that government officials are in a position to use their incumbency to advance their electoral prospects during an election period. However, broadcasting service licenses should regard with particular caution any statement or action by an official or incumbent of a political party. It goes on, but it is just a guideline. As ICASA, we don't regulate. So in the main, we are saying they need to be, or to take caution as they do these things. I think I have covered it, but we don't regulate that aspect. Thank you.
Advocate somebody?
And nothing to add from my side, Honorable Chair and Honorable Minister. Fikile has covered.
It seems to be clarified, Honorable Chair, in my view.
Thank you, Honorable Minister, and thank you to the ICASA team for all the clarities that have been given to questions asked by honorable members. I take it because I tried to give space to the hand that has been up from Honorable Mazone at that time, and it would appear that it may have been raised by mistake. As we summarize, I think...
No mistake, Chair.
I didn't hear you.
Chair, it's no mistake. The hand is still raised.
Okay, no, I gave you space, but you didn't respond to it, because I wanted, when that response was to be made, that the point you want to raise could then be covered. But of course, I won't want to close you out.
Thank you, Chair.
It may be important what you want to raise before we release ICASA.
Thank you very much, Chair. Chair, the point of clarity that I wish to raise, and I thought that you'd cut me short, not because you were cutting me short, but I thought because you thought that the next ICASA council member was going to answer a question further, which in actual fact she did and did not, because it's raised perhaps a new question. Now, the minister said that he wasn't going to be naughty, but perhaps he was slightly naughty in raising the fact that Alan Winde must be given an opportunity to inform the public as to the work that he is doing, and be able to broadcast that work to his community. Chair, without being in any way naughty myself, if Alan Windley was to do that, he would take up 99.9% of the broadcast time. But Chair, in respect to what the council member answered the minister to that question, she clearly indicated that government has to continue doing its work and that government officials must then be able to communicate on work that they're doing. And ICASA then has a duty to regulate and to monitor that only government-related work is then reported on and that it is not viewed as unfair electioneering. Which brings me to two questions that I have, Chair, and it's two quick questions. Chair, it then brings me to this issue that I've had for a while now, which you and the committee know, as to why then, if government work is going to be reported on, and just government work that is not electioneering, certainly in this 13-part MDDA program that they have released, they will be including governments that do not only include the governing party, but that include parties that govern elsewhere in the country, because our country is not governed entirely all by one political party. That's my first question to the ICASA Council. And then the second question is, it's a very simple answer to this question. Is there going to be a cutoff date by which broadcasters must inform ICASA of their intentions to run PAs? And that's it from me. Thank you, Chair.
Yeah, I'm sure ICASA would answer to those specific questions, of course, minus whether it is the minister or Honorable Mazzoni who's probably not here, so that it's not part of my summary. Can we get ICASA to answer specifically?
No, thank you. Direct to ICASA, thanks. ICASA, can you respond?
Thank you, Minister and Honorable Chair. So maybe to start with last question. The PAs obviously run during the election period, and we are not going to have PAs running beyond the election period. And the regulations do specify when it is that political parties and independent candidates must submit PAs to the broadcasters, so that the broadcasters can check whether those PAs in particular are in line with what would be the content of a PA before they are broadcast. And also in terms of the first question, again, I'm not sure I understand what it is that Honorable Mazzoni is saying in terms of the coverage of government officials during the election period. And at the risk of repeating what we've said, ICASA is regulating PAs and PEBs. And we also make sure that we guide, or at least we set out what the principles are for the broadcasters when they run these PAs and the PEBs. We also caution broadcasters in terms of information, or at least the use of the election period, or at least the run up to the election period, for other things other than what it is that ICASA would be regulating. But as to instances where it so happens that the information that is then broadcast through broadcast during the election period, which probably should not be broadcast as such, there is an opportunity to raise that either through the monitoring that ICASA would be doing, as well as through the handling of complaints if it escalates into, if the issue that is being raised escalates into a complaint. So I don't know how further we can really take the issue that is being raised here, other than to say that. I think that's it from my side, Honorable Chair, unless anyone from my team wants to add. Thank you, Chair. Honorable Chair.
Are there additions?
I guess that's where it goes. That's the best has been tried to respond, Honorable Chair.
Thank you, Honorable Minister, and the ICASA team. I take it indeed that there's been an effort to respond to the questions as far as it's possible. But what is important is that I think what we said earlier, that we really appreciate that ICASA was ready through your leadership, the Minister and the Department, to come and brief us on the state of readiness. I think this has been beneficial. And you can also test it with the interest in engaging the matter before us. And I think ICASA has been able to rise to the occasion. I think ours is really to support them in doing their work. As members who are drawn from different political parties, that will also spread the message to our caucuses that there's a need to adhere to regulations. That's the only way you will make the regulator effective in doing its work. And when there are challenges, we now know areas of referral so that those matters are attended to accordingly. But coming out of the meeting better clarified in terms of what would be regulated as electioneering vis-a-vis the need for the government. And by government, we were clear that it's at the different spheres of government that they continue to communicate to South Africans in terms of the official government work that they need to communicate. And that would not be misconstrued to be violation of the regulations that ICASA would have put up. Of course, we do appreciate, Honorable Minister, that with all the difficulties that the community radios in particular are experiencing, that ICASA is also considering the submissions that are made, yes, of course, on merit. And if I were to stretch that merit, indeed would also speak to ensuring that the fear we have as we look at the period is that some of those get to be hijacked by other interests other than that of ensuring plurality of views on the ground. That will be able to to look at that they adhere to such. But it's an important opportunity that they can also play a role in this period, and that ICASA is considerate of such a request. So we appreciate that. I must then once again thank you, and we have no intention of holding you here when necessarily you needed to ensure that the invites for the workshop of the 5th of March are out, and that people are confirming that indeed it will be a success. So we'll release you if you so wish. But if you decide to stay on the platform, we'll proceed with the agenda of the meeting as we move towards the closing hours. So that's with regard to the item on ICASA. Like I said, if you want to stay, you stay. Committee support. Thank you. Committee support will then get to the minutes. And as I said, Honorable Mazzoni, I promised that I'll come back to this point when we deal with minutes, because I'm assuming that in the course of travels to Parliament, there may have been gaps in that regard, but also just to speak to other developments. Maybe the first thing is to talk to the training that we said we'll have every Tuesday. That we got a request not to proceed on the basis that today, I think one of the platforms was to be engaged with the IEC on similar matters, and the other with the Competition Commission on other matters. But there's still commitment to come back as is the committee in the remaining days. So I thought it's important because it's also in the minutes. The other point relates to the point on the program. Honorable members, the program has been amended on the basis of you raising the point that the entities as they come, the agenda is overloaded, and you need space to be able to engage with each of them. And of course, the department through the ministry, the response was clear that it is the committee that schedules, not because they don't have time to come before the committee and elaborate further on matters. So we then would have looked at those that we have raised issues on them, quite critical to deal with the SABC, be it the commitment that the minister would have made on bringing back a ministerial task team to give us a sense of the turnaround they're doing, etc. Be it the oversight committee on the SAPO business rescue plan, that we need to keep an eye on that. So we prioritize those, link them to the training program, because we thought that even the training program is a step in the right direction in building relations between the committee and those platforms, something that we struggled to have in the beginning. So it's informed by your inputs, Honorable, and we're responding positive to the inputs you've made. But of course, as we're to end the meeting, at that time, I want to place this on record, at that time, we didn't have an election date that has been announced. We will probably learn about it after the meeting. But at the time of the meeting, we were informed in the main by the submissions that have been made. And in the way we look at public participation, probably may not come from the same orientation. But from our orientation, we're not doing it for the sake of doing we have to listen to what is being raised, but also that we ourselves would have also had issues we raised. Amongst those, I want to put that as an example, which was more of the committee problem. You will understand the difficulties we had with the appointment of the SABC board. After the term of office would have expired and the board wasn't disbanded, but the term had expired. But the law did not make provision on what are the interim arrangements pending an appointment of a permanent board in that situation, which is Section 12 of the Broadcasting Act. And of course, we have an opportunity now to deal with that matter, but the bill as it stands doesn't talk to that. We've also reflected that in the main, the bill was also about addressing the funding model for the SABC. And as the bill stands, it talks about a 36 months period on which the minister must then develop. Now, I'm just citing those examples, which are also stated in the submissions, if members processed the information that was given to them. Now, it would have not made sense, especially when some of those submissions are quoting case laws that have already been decided by our courts on certain matters raised in the bill. So we then took a posture that it will not help to just rush the bill because we've put up a program, but that we are advised legally so, whether these matters may probably need drafting, whether this can just be answered in the process of engaging on the bill or advised in any way. So we then had to strike the balance that if you are taking it to legal, they themselves must process the submissions received, right? Of course, and the concerns were then advise us accordingly. So it would have not made sense to have a public hearing in that period until we have got this, so that the committee can then make an informed decision based on what we are advised on. So I'm saying this is before we even had the election date announced. With the announcement of the election date, it makes that position we took to be even more concrete, in that there's also an issue about the time. That time that ensures that we do mean what we talk about as participatory democracy, that we do not engage the public as a compliance matter, but it is because they have to participate in the making of legislation. So then our position in that score is understood. So as to be clear, it was in the committee last week, and there was no objection to that approach. And we closed it by saying that that then gets postponed until further notice once these matters are clarified. So once clarified, we'll then come back on and apply our minds, taking everything else into consideration. And of course, we are not, we don't have to undermine that this is the renewal of this act after a long period of time with a lot of changes that have happened in the space. So when you introduce the law, it should also be relevant at times if one has to put it in that way. So it's not an abrupt decision, probably from the chair or so, but it is what this committee last week would have supported. That summary is correct. Let's give it a time, because we're not doing it for the sake of doing it. and that we are advised legally also in that regard. So that when we engage, we know we are engaging in a fruitful exercise. So that we don't just do it for the sake of doing it. But as I say, the election date just come in also to justify the need to really look at it in a proper sense, whether we are capable as the committee of addressing all the concerns that get raised in a way that makes that law to be the law you can be proud of. Subsequent to that, we have received a letter which in previous situations, once the letter is said to be circulated also to members by those that write to us, we'll take it that it's circulated. But we've also asked the committee to do the same. But the chairperson has an obligation to respond to correspondence that's sent to the office. And in this case, one of the organization representing a number of organizations under the umbrella SOS wrote to the committee. We do know their stance has always been that from the beginning, that we probably need to reject or not deal with the bill. And we justified why we needed to consider it when it's before us. So they wrote, of course, their point was about the public hearings, that it was probably short notice, which we have been able to respond to, but emphasize again their point that in a way, from a point of positivity, it gives space to the committee to really apply its mind in considering the bill as it stands. Right. So we've responded to that question, and I hope members would be looking at that, and that even them, if they are following the deliberations of the committee, they would know that it is not out of malice that we had to send it to legal, but it is to really help equip the committee to be realistic in how it engages the bill, the SABC bill. So that's what happened. So I'm just saying it may have been missed at the time of people also traveling physically to Parliament, whilst they may have been on the platform. But there was no objection, but support that under the circumstances, it is proper to look at it in that way. And I can confirm that legal has confirmed having received all documents and they are processing the matter accordingly. And in our summary, we then said, if there are matters to clarify with the department, they will certainly do so that when they present something to us, is quite conclusive. So I just thought it's important to give that background so that when we have 2 minutes, like we did previously, is to lift up the important matters that come out of that may need a bit of progress reporting to the committee. So that's basically that in response to your point, Honorable Matsoni. But because when we deal with the minutes, it's just a mover and seconder. If there's any clarity needed, or if you are clarified, you can give that indication, because your hand has been up as I speak, so I was not sure whether it's order or not, but I just thought I should complete the point so that all members get it. Honorable Mazon, like I said, your hand has been up. So I wasn't sure if it's point of order, Chair. So, but this is an opportunity you can speak.
Thank you, Chair. Chairperson, there's absolutely no need to ever call a point of order on you, because you're a very fair chairperson. So please don't think that when my hand goes up, it automatically means a point of order. Chair, I'm normally in agreement largely with the way you conduct the meeting. So please, I ask of you to give me the benefit of the doubt that it's not a point of order. Chairperson, let me explain where I think the confusion has come in. You are quite correct that we were all in agreement that the public hearings were too quick, that there wasn't sufficient time given, that there wasn't sufficient notification given. And most importantly, Chair, I think that as a committee and as a chairperson of a committee, you were completely aware of the fact that we could be facing an election date, which we now know was in fact the case, which is in a few months' time. In fact, I think it's about 90 days away from where we are now. So it will be impossible for us to do justice to this bill. Chair, I think where the problem comes in is when the program is then circulated and on the program is listed finalization of the SABC bill. And that is allocated for a date, if I'm not mistaken, on the 9th of March. So, Chair, that is where things become problematic, and that is where things become confusing. And that is where not only you as chair, I mean, there's no way you as chairperson can be blamed for it. The committee decides on that particular program. So I think, Chair, that we have to work as a committee, and we have to now decide today, before we have public participation, before we have legal opinions, before we have received all documentation pertaining to this SABC bill. And Chair, believe you me, I have been following this with an absolute eagle's eye. I have not received every piece of documentation that has been sent into this committee regarding the bill. What I do know is that over 100 submissions were made. 3 were in favor of the bill. The others were not in favor of the bill. Only this morning did we receive the letters from the umbrella bodies to which you refer, and your response there too, which indicated that we would not be continuing with public hearings because, gratefully and rightfully so, we will not use the public simply as a rubber stamping board, and we will not use public participation just as a joke. We take public participation exceptionally seriously. So, Chair, this is my request to you as chairperson of this committee, and I'm asking you to put it to the committee. Can we remove from the committee agenda deliberations and finalization of the SABC board, of the SABC bill? Because that is what is causing the confusion. That is what is causing unhappiness within the general broadcasting and interested community groups across the country. It's causing confusion for us as members of parliament, because of course we cannot finalize a bill until there has been proper and sufficient public participation. So, Chair, we know this isn't our first rodeo. We know how Parliament starts to wind down towards the run-up to an election. We know that we have an end of term coming at the end of April. We are already now almost at the beginning of March. There is no way that correct, deliberate, and sufficient time and observance to what is required of this bill can be given in a period of less than a month's time. So, Chair, I'm requesting of you as chairperson of the committee to have references to the SABC bill, and certainly the reference to the finalization of the SABC bill removed from our program. Thank you, Chairperson.
Thank you, Honorable Mazone. I now recognize the Honorable Majozi, who will then be followed by the Honorable Mdagane.
No, thank you, Chairperson. Firstly, Chair, I think maybe your explanation is welcomed as you are putting it. But also, I think it is fair as this committee then to say that we have submitted to legal years, and after now receiving the proclamation of the election date, we'll need to sit and look at then how then do we do these public hearings so that they don't just serve the purpose of just doing them. But also we need to have time frames. When is the legal coming back with whatever response? And also, when are we going to still discuss this in a meeting? And if not, then I think I would support Honorable Mazon that, which means we're not going to deal with this bill in this sixth term of Parliament. We're only going to defer it to the next Parliament. If that is the case, then it must be then removed, because I think that is what Honorable Mazon is saying is causing a lot of confusion, because now we are getting a lot of calls from media to say you have cancelled the public hearings on the bill and so forth. So you don't even then know how to respond, because the letters, and also the letter that we've just received in this morning, can I get a clarity? When did we receive it? When did our secretary receive these letters as we are receiving them now this morning? Because there have been submissions that people are calling us now, telling us there were letters that they were sent, but we don't even have the advantage of those letters because we have never seen them. So if maybe we can then get a clarity on when are we supposed to, the time frames as well. Are we and be realistic? Are we going to deal with this bill this term? If not, then let us remove it so that we know that it is deferred to the next term, and then it is easier to respond that the bill is deferred to next term because of time constraints, and we don't want to just do the public hearings, but we want to do a thorough job. So whoever would be appointed back in the 7th Parliament, whoever will be appointed back in the 7th Parliament will then they will then take over in the bill. So yeah, we would need that, Chairperson, so that we get clarity as well as members, and we are not found wanting when we are asked these questions. Thanks, Chair.
Thanks, Honorable Majos. Just make sure the lobbyists around you get close to the mic. They may affect the input you make.
Yes, my apologies, Chairperson.
I hear lobbyists. The Honorable Dagane will be followed by the Honorable Mula.
Thank you very much, Comrade Chair. I think we have assisted us really to elaborate on the reason why we took that decision when we met last time. It is very clear, Chair, at the time we took a decision, none of us was aware that the elections were going to be in May. As we know, Comrade, all of us were talking about, some people were talking about the end of August or in August. As a result of that, I do think that it was correct for us to take the decision that we have taken. But given the development now, I think it is proper, Chair, that we allow ourselves enough space first to get the information from the legal side of things, because we can't just simply go for a fruitless expenditure. If we are aware now that the 29th of May are elections, we start a public hearing, that would be just malicious compliance, which is, I think, would be problematic to explain politically as a chairperson of a committee on behalf of all of us. I think the explanation that we have given should be accepted, Chair, that we should consider in this meeting agreeing that the bill should be deferred to the next administration, meaning the next Parliament, the 7th Parliament. I think we should try to do that, Chair, if that is not going to cause any harm to anyone. Of course, all of us, Chair, would have loved to deal with this bill once and for all, finalize it deal with the uncertainty about some of the issues of funding and many other issues that are raised by society in terms of their submission that we have read. I've not read all submission, but the submission that I've received and read is very clear, Chair, that it's important to allow the public sufficient time to engage in this important national bill. My view, Chair, is that, as you have made a point, that we should really consider and be persuaded by your explanation and accept that the bill may be considered next term, or not next term, by next parliament, the 7th parliament. I think I will support that, Chair, because I don't think it's causing any harm to us. I think it would be very harmful if members of this particular committee can take a decision knowingly that public hearing by their very nature, no one can decide and then also determine exactly what would happen in public hearing. We know it's a very interesting bill. It also has raised a lot of interest in the society. I think it would be a good idea, as you said, Chair, that we should do thorough public participation. I think the structure that can do that, or the body that can do that, is a body that is going to be an outcome of the election on the 29th of May. I support, Chair, the idea that we should be persuaded to defer it until the 7th parliament. Thanks, Chair.
Honorable Mulala.
Thanks, Chair. I think, Chairperson, most of the latter speakers are agreeing with your summary. I also agree with the summary, Chair, as presented by yourself. Maybe the two critical issues that comrades and colleagues are raising is around whether this meeting should finalize the fact that the bill is now officially deferred to the next parliament. But what we are also not looking at is that as much as I agree that there's no time to finalize the bill, or even if we wanted to, it will not be possible. But the reality of the situation at SABC now, I would then propose to the minister that let's look at how best can we engage Treasury, because we can't leave this public broadcaster to collapse, looking at the fact that the bill somehow was intended to assist, particularly on the funding model, which, of course, we had some questions around the way the bill is presented. But for me, it should not just stop by saying, yes, the bill is deferred, but how then do we defer the bill without us getting the legal opinion on the matter? It must not create an impression that we are running away from the responsibility. At the same time, what if people challenge us on the retracting of the bill? Why are we retracting the bill when it was already here? So for me, maybe let's agree that in principle the bill is deferred, but it may be important that the legal advice be presented possibly in the next meeting just to confirm our decision. And I will be very, very comfortable. But I think we should take the matter up again on the status of the SABC, perhaps beyond this meeting. But now that the minister is on the platform, I think we must then start further engagement, maybe at the level of the committee, how best we can assist. Because if the implication of leaving this bill means the SABC will collapse just immediately after elections, and they will be expecting the new parliament to start afresh, would have done a disservice, because we have seen, we are doing oversight of SABC now. even before we leave, is there anything that we can do? If there's nothing, fine, let's accept as a committee that there's nothing we can do. But in principle, I agree that the bill be deferred to the next parliament. Thanks, Jim.
Thank you, honorable members. Maybe before we close the matter so that we approve then the minutes, at least there's a bit of a recollection of what really happened in the previous meeting. Honorable Majosi, is that an order?
No, Chair, it's not an order, but I thought maybe we'll have a second bite once you respond to the questions. I would want to then maybe propose something as well.
Now you must propose, Honorable Majosi, because once I speak on the matter, will now be giving direction.
Chair, I would also propose that as we have a statement, then we take out a statement that would elaborate why are we not dealing with the bill, because honestly there'll be a lash out that which means we were running away from something, and maybe the submissions that we got were not in favor of what we wanted. So that is why now we want to defer and derail the bill so that it reflects what we want. So I want us to have a statement then that would be taken out to say this is these are the challenges that we are facing, and this is how we sought to deal with the bill. And maybe if we do agree after getting legal, that then we defer the bill to the 7th Parliament, and those people will be then eligible to deal with the bill at that time. That's all, Chair. Thanks.
Thank you, Honorable Majosi. I think it was important to give you first so that I cover this in summary. Honorable members, appreciate your contributions to the matter so as to better clarify ourselves, but also South Africans out there. Maybe let's start with the point about letters so that there is no suspicion that there may be information withheld from members. There is no 100 applications or letters sent to us. I take it that Honorable Mazon was just emphasizing a point because that will not be true. Not true because all the responses to the bill were presented here in the committee. Ono said what, including an analysis report from the content advisors on what comes out of the submissions that have been received. So it's a transparent process. So even those that made the submissions do know that their submissions were acknowledged publicly. So it's important to just put that aside. And of course, on the part of the letter, I've responded to the letter very late yesterday when I saw it, and surely that's the reason it would be in the circulation in the morning. But what has happened before, which is what I raised earlier, was that once it's copied to members, members usually get that directly without the chairperson circulating it. And I've responded, even though it's circulated to members before, to letters that come before my desk. And I do that on behalf of the committee as the rules expect me to do, that I act on behalf of the committee on matters, especially those that the committee has processed. So that would have been done in that way. So there's no information, honorable members, that's withheld. The second point, it is the duty of stakeholders to lobby all members It depends on how you react to the lobbying. And I think from where one is sitting, they will continue to phone you, honorable members, because you must be accessible as members of parliament. Just like they will do with the chairperson who's a member of parliament and a member of this committee. But it depends on how we respond to that. And from where one is sitting, it will not be that we are running away from dealing with the matter. In fact, we are dealing with the matter. Because if we do recognize the submissions made, irrespective of where they stand, and then say we need further advice on this so that we don't rush it because we think we can, we do so. And this is not new. I want to remind you, honorable members, we had the situation when we were dealing with the bill. We had one stakeholder responding. We extended many times to ensure that even members encourage stakeholders to respond. Why? Because we take what comes from the public indeed exceptionally serious, Honorable Masoni, in the true sense. So that even if we believe in something, as Owartamo would have taught us, is that if it is not finding expression with the people, we will change that position even if we believe in its correctness. That's what we're doing. So we have an orientation, some of us from a point of understanding public participation. And the reality is, if people quote case laws and all that, the reason we have legal to support us is that we may not all be lawyers as public representatives. And that's why there are professionals put to assist us in that regard, so that we make informed decisions that can also stand legal scrutiny. Because we make laws here, and these laws must also stand the test of the Constitution and so on. So this is what it is. It's about listening to the people. And that when we come back to them, we'll respond with facts before us. Now, therefore, I want to advise honorable members that it will be putting the cart before the horse to take a decision when you have referred a matter to legal to advise you. And I know we asked you to advise, but we're taking a decision now. We're no longer in that thing. It will be wrong. In fact, that's where, from a point of perception, it will be like we were just maliciously complying by asking for legal. Otherwise, we've already got views on the matter, and that this is the view. No, we should give legal the opportunity to do their work, advise us properly, because whether at the end we agree to defer or not to defer, we must advise the next parliament in any way properly, because we have also been advised properly. And in that way, it safeguards the process, because the rules of the National Assembly are such that once the bill is presented before the committee has to process the bill. So all the actions we are taking at this point are about processing the bill that is before us. As to what the outcome later on would be, it will not mean we didn't process the bill. It will be out of processing the bill that we ultimately arrived at a particular decision. So therefore, the part about the program, it may be wording that is put, that instead of saying discussion on the bill, you put finalization. Like I'm saying, there have been many versions of that amended program with the changes in the agenda items and so on. Sorry, there may have been a slip up on that. But we have to take the discussion on the bill. It must be on our planning, so that when legal presents, we give them the opportunity to do so. We interact with that presentation. We make the call as the committee and then advise Parliament accordingly. That is our proceeding with the bill, whether it is about deferring, it's part of proceeding. If it is such that within the timelines, you are able to look at these things that can be redrafting or whatever is called, will then be advised accordingly. So that our deferral or not deferral is based on facts before us and the advice that we've received legally. So I don't want us to take a statement, Honorable Mashozi, that says the bill is off and so on. There are other people who can also take us to task. What is the basis? So you have to create that balance at all times. And this is the best option that we looked at in the last meeting. Legal advice, take the decision ourselves. What do we do in that regard? So we can clarify in the statement the reasons why the public hearings, we put them aside and so on. But the matter is still on the table as we are awaiting legal advice as per the decision of the committee. I also don't want us to say to the nation, the legal advice will be given in the next 2 days. We don't have to rush it to a point that those that needed to do a thorough job will then say, no, we couldn't give you a conclusive advice because there was pressure that we must deliver in 2 days. They know it's urgent because we need to make a call. But we also need to create space that they process the information that is before them, and therefore they would have made their call on the basis of that. This is very helpful when there is a challenge, even on what they've put up, that they can be able to defend the opinion that they would have given. So I think that's how we are managing it, honorable members. But the point raised by Honorable Mlala for me is an important one, which we must discuss whether at a time we get this from legal or at the time as per the program when the SAPC presents the corporate plan. Honorable Matsone raised it in the previous meeting when we're dealing with performance in terms of quarterly reports and so on, but raised it, I think not concretely, but more to expose that certain things could have been done differently, because the point she was raised that if we are unable to spend on this and that, why has the money not been put together to help the struggling entities like USAPC and Post Office, right? So that you don't report that we can't spend, there were no plans, this thing came without a plans and so on. But I'm saying it was raised in the heat of a discussion. We may need to engage that when we look at the corporate plan or when we deal with the actual bill. That even the bill, Honorable Mlala, once it suggests that the financial model will be something of 36 months after you pass this, that the minister must look at it. You may not have the SABC at that time, right? Because it's struggling as we speak. Which therefore says that irrespective of our political affiliations and ideologies, we need to answer the question. If you have a public mandate that must be served by the SABC, is the appropriation that we make from the fiscals commensurate to what you expect the SABC to do? We need to answer that question. And in answering that question, it therefore says this point you are making, Honorable Mlala, engagement between the department and Treasury, that if that public mandate has to be served, how do you assist the SABC? Pending whatever legislation that you would have, because currently there is legislation that regulates broadcasting, and you expect them to deliver on that public service mandate. I think, as I say, irrespective of where we stand politically, but if we are all interested in the SABC that is able to ensure that the community is informed, is educated, and it's entertained, and that they must access it at any given time to a point that we spend money even on the broadcasting digital migration because we want to improve the service to who? To the people. So you need to deal with that aspect. So it may not be the meeting to deal with that, but I'm saying it's a choice we'll have to make whether we deal with it when we deal with the corporate plan, because the corporate plan surely should also be saying how they will be able to implement it for funds. Are they doing that? So we can deal with it in essence separately. That will be the guide I want to give to the meeting, that we put it maybe in one of those items. But at least let's be clear on this one, that it was not just malice to send this to legal. It's because we wanted to be advised. Let's wait for the advice, to make the call. As I say, whether it goes this way or that way, it wouldn't matter. But we've got a record in the other bill where we really went out to get public inputs, and we did get those. We considered them, we quoted them, even at the time we were putting up such a bill. So I'm saying, honorable members, that's how I want us to close on this matter. Like I'm saying, it doesn't take away that the stakeholders will forever lobby. They'll be lobbying us. But as they do, let's also help them to understand that we have an obligation to process the bill that is before us. And the route we're following is this route that we are following. We'll make our call in due course. But when we do that, we'll take into consideration that participatory democracy is something we fought for, that our people participate in shaping up legislation of the country, and we'll stick to that. So it's not a rush because there's election and so on. The implications of the law you make, it's not just about the election, it's also beyond elections. So we're not being forced to a situation. So let's understand it in that way. So that's how I want to close it on this one, honorable members, as we get to approve the minutes. Ajira, let me do the minutes.
I'll share
Or
them.
am I the one disconnect?
Are you able to see, Chair?
From where, yes, I am, I can see. Honorable members, I hope you are able to see as we go through the minutes. Just hold. There's something there on opening remarks of Minister. I think in both instances, just for consistency, because the opening has been done by the chair in the first item, that usually is overview by ministers. You'll correct that, can't go down. Any corrections? If no corrections, can I get then those that have made a mover and seconder? Honorable members, can you help us move? Did a mover and seconder for the minutes?
I move, Chair.
Honorable Lala moves. Can I get a seconder?
Chairperson. Chairperson, are you there?
Yes, I am. I'm just waiting for a second to Honorable Mulala. Unless it's me who's disconnected, I couldn't hear.
We can hear you, Chair.
No, I'm saying I didn't hear who seconds for record.
No one yet, Chair.
Yeah, so I'm checking the members that were present and check what they think about seconding.
A second, Chair.
Any objection to us adopting the minutes? So no objection. So the minutes are agreed to and approved. May I just check, Ajira, in terms of your agenda? I know that I had raised an issue about one employee, which will deal with it as we close the meeting.
That's correct, Chair. That was the last on the agenda. Thank you.
Okay. Honorable members, I've been informed that Mr. Edward Force, Mr. Force is popularly known by members. Probably this is his last attendance of our committee meetings after serving Parliament 29 years, 10 months. Of course, I want to take the opportunity on behalf of the committee and of course all the support staff that have kept this committee going as we move towards the end of the term, of which Mr. Force has also been one key person in that regard, that we appreciate his contribution. And I know different members have had interactions with Mr. Force, especially when either we prepare for the oversight or the committee work. You'll have to interact at times with Mr. Force to ensure that the logistics and other things are taken care of. Yes, I must say lately, Mr. Force, when that engagement has to happen, you will be doing that sometimes in your bed because you probably have just been to hospital and so on. And that's, I think, for me, a sign of commitment to your work. And we really appreciate that. And of course, there will be light moments in that engagement where Mr. Force will speak as the old man who's really going anytime, and will always say, keep it up, old man, you're doing well. So we really appreciate. So if there are, of course, members and committee support staff, I see Mr. Ngoma there. Maybe he wants to clarify one or two things. But that's really that. The COVID, of course, has kept us far apart, and I'm sure for new members, they only know the name. They may have not met Mr. Force in person, and I'm sure at some point he will open up his video if he's able to in the right space, so that the members see we have a new member that's coming into the committee who may not experience the same in the remaining period, Mr. Force. So I'll give Mr. Ngoma first, that you'd want to clarify or say anything, and if there are members who would want to say one or two things as we bid farewell to Mr. Force. Mr. Ngoma.
Thank you, Chairperson. It's still morning to you and morning to members, officials of the department, as well as guests. And Chair, if I could just request that Mr. Edward Force switches on his video so that people can know the person that you are talking about. I had asked him that I would ask him to switch it just for a spare of the moment so that his face can show for the last time in the screen. Chairperson, as Mr. Force is busy with his camera and showing his face, there he is on the screen. You are correct. Mr. Force, Edward Force joined Parliament in April of 1994. He's leaving Parliament having served 29 years and 10 months. It would have been 2 months if he had just stayed on until April. It would be 30 years within the institution. That's the age of the bond freeze. Chairperson, when Mr. Force started at Parliament, he started as a service assistant, a service officer, and then over the years he was promoted and was placed at the International Relations Unit, where he served as committee assistant, and that in that position he served until 2012, when he was then when he moved to promoted to committee assistant within committee section. And throughout those years, Mr. Force was able to educate himself, because as he leaves Parliament, he had obtained a bachelor degree in public administration, something that is an encouragement to us youngsters, because he was able to acquire that degree at his old age. Chairperson, on behalf of the committee support staff, this committee and the institution, would like to thank Mr. Force for his dedicated service to Parliament, and also that he was able to serve on the Committee on Communications and Digital Technologies over 3 administrations, the 4th, the 5th, and the 6th administration, and would like to wish him well in his retirement, and he will definitely be missed. Chairperson, you know, this is one gentleman that conducted his work efficiently and diligently. He was able to keep up with the pressure that come from my office, as old as he is to me, but we have always maintained a mutual respect. I respected him as a colleague and as a father to me, and he respected me as a colleague and as a son. On those words, Chairperson, I would like to thank Mr. Force for his service once more and wish him well in his retirement. Thank you very much, Chairperson.
Thank you, Mr. Ngoma, for that brief journey of Mr. Force. If there's any member, so that I don't leave members from commenting as we move towards closure. The Honorable Bodani, who says we didn't see the face. So, Mr. Force, you are asked to put up the video as they speak. Honorable Bodani, you've had your experiences with Mr. Force.
As thank you, Chairperson. As Ndate Maleka would say, Papa Force, everything of the best. I wish you nothing but the best. I hope that your health gets stronger, and I really hope you do take that long overdue overseas trip. Enjoy your retirement. You will sorely be missed. Thank you for your work to the committee and indeed to the country. Everything of the best. Congratulations on serving 30 years. 2 months less does not matter. You've been a great South African. Well done. Thanks, Chair. And I don't know who's going to say Madam. Madam.
Honorable Matsole, I see your hand.
Thank you, Chairperson.
Honorable
Chairperson, am I audible?
Yeah, audible now. You can proceed.
Great. Thank you very much. Chairperson, from my side, me and Mr. Force have worked together for many, many years. So I would kindly ask people to stop calling Mr. Force old, because we're not old. We are simply well experienced. Mr. Force, I wish you a very happy and well-deserved retirement. I hope you get to spend time with your friends and family. I thank you for the service to Parliament through all its ups and downs. I thank you for the service to your country. I thank you for your service during times of good health and during bad health. And I wish you going forward nothing but good health and happiness. It's always sad to say goodbye, but with every goodbye comes a hello. And I'm sure your family is very grateful that you won't have to be sitting in Parliament or on Zooms, and they can now have you all to themselves. So my very best wishes to you and your family. I wish you good health, great happiness, and a very happy retirement at your great young age, that you are still able to experience all the joys that life has to offer you. Go well. Thank you very much.
Thank you, Honorable Matsone, Honorable Majosi.
Thank you, Honorable Chairperson. I think when I said the face, I wanted to be sure who I'm speaking of. But to Mr. Force, I've got nothing but gratitude. And as Honorable Bodlane has said, no one now will call us on our oversight and call that, Madam, we have booked you and you must confirm and stuff. But thank you for serving us with respect and the kindness that you have shown to us. Please possess that wherever you are, and God bless on your life and prosperity as well. Thank you.
Honorable Majosi, because I don't see any other hand. I'm sure Mr. Force who is still on the platform. You would have heard the members. You may not speak to them after this. So you probably would want to say one or two so that we conclude on that, respecting you. Still on the platform.
Yes, sir. I'm still on the platform.
Yes, yes.
Yeah. I didn't prepare the speech, and I'm not a good public spokesperson. But I would just want to say to the chairperson, all honorable members, thank you for the kind words. And Tim Nkosi, he knows the ups and downs that we had over the years. It was a great honor for me to work with the members over the years, especially this last committee. There was, as I said, ups and downs, but we overcome all the obstacles. And I think there comes a time in your life that you realize it's time for you to step back for the younger person to take over. And I enjoyed my years to work with the members, as I was calling them madams. So I will miss all the madams and all the gentlemen and all the chairperson and all the members, Mr. Molala, Mr. Madakani, Mr. Gumbu, Honor Kubeka. It was a great honor to serve you for the last 29 years at Parliament. But I think it's time for me to step back to enjoy the time with my wife and my 3 grandkids, and it will give me the time to go and visit my daughter overseas. That is a long overdue. Thank you for the time, members. Keep well. God bless you. Bye-bye.
God bless you too, Mr. Force.
Thank you, Mr. Force, and thanks to the committee support for bringing this to our attention, so that we never forget those that may not be in the limelight, but are doing quite a serious job behind the scenes to make sure that we shine as the committee in our work. So we really appreciate Mr. Force. You'll have good time, as members would have said, with family, even though it takes a bit of time to adjust to the fact that you are not waking up to do anything sometimes, because they want to spoil you for the time you spend with us. So please enjoy the time. That, honorable members, would take us to the end of the meeting. So this meeting stays adjourned until we meet again.